contract performance, breach, and grounds for contractual disputes. Performance of a contract for the sale of goods is governed by the Uniform Commercial Code. The rules involving delivery and supply of goods are generally designed to protect the consumer. Firstly, the contract is performed only when the goods, exactly as specified in the contract, are supplied from the seller to the buyer. The goods have to be perfect, otherwise the contract is breached. This is known as the perfect tender rule. Anything less than perfect goods being delivered perfectly on time is a breach of contract. So of course, the buyer can reject the goods that are not as ordered. If the buyer does accept the goods, acceptance is final and cannot be reversed. Acceptance can be explicit when the buyer states or writes, "Thank you for delivery of the goods, they are exactly as ordered." There's little doubt that this dialogue constitutes acceptance. Payment without opportunity to inspect does not constitute acceptance of the goods. If the goods when examined are faulty, then they can be rejected, and the contract is breached as they are imperfect. If, however, the buyer keeps the goods without objection for a period of time, this creates an implied acceptance. By keeping faulty goods and failing to return them or inform the seller that the goods are rejected, the buyer is deemed to have accepted them. Partial delivery is a breach of contract unless delivery in stages was allowed for in the contract. If the buyer orders 100 but receives 50 with a promise to deliver the remaining 50 at a later date, this is an imperfect tender by the seller and a breach of contract. However, if the contract allows for part delivery, the seller is not in breach. If the seller provides non-conforming goods and they are rejected by the buyer, as long as the delivery deadline is not yet reached, the seller has a right to try to correct by delivering perfect goods conforming to the contract. The rule that acceptance of the goods is irreversible could create some injustice when serious faults in the goods are discovered after the goods were accepted. Let's say the buyer purchases a watch in October as a Christmas gift, wraps it up and saves it until Christmas Day. What happens when the gift is opened at Christmas and it's discovered that the watch fails to keep time? When the buyer accepted the goods from the vendor in October, the vendor's performance was completed. Well, acceptance of the goods cannot be reversed, but it can be revoked if the goods are later found to have a non-conformity that substantially affects the value. To revoke prior acceptance and put the seller in breach, the buyer must have a reasonable excuse for delay in discovering the fault and must promptly revoke acceptance. In our example, a watch that fails to keep time is a substantial non-conformity that substantially affects its value, and as it was a Christmas gift that was untested before December, there's a reasonable excuse for delay in discovering the timekeeping problem. The October acceptance can be revoked and the seller placed in breach of contract if the buyer acts within a reasonable time, in this case days rather than weeks, after the Christmas Day discovery of the fault. Many contracts contain conditions on performance. If the buyer says, "I'll buy the mare for $1,000 if she's in foal," the promise to buy is contingent upon the mare being in foal. If the mare is not in foal, the buyer doesn't have any obligation to purchase her. If the mare is not in foal, the seller is not in breach. With a condition like this, the buyer cannot claim breach of contract, as the seller is not warranting that the mare is in foal. The confirmation that the mare is in foal triggers the obligation to buy at that point, but not before. The meeting of the condition triggers the obligation to perform. If the buyer says, "I'll buy the yacht if I can raise a loan," the promise to buy is contingent upon the buyer being able to raise a loan. There is no breach and no obligation to buy if the buyer is unable to raise the loan, but if the buyer is in breach if he fails to make a reasonable effort to raise the loan. The condition must be strictly complied with for the obligation to attach. So a promise to pay $500 for a pine fence will be unenforceable if the fence is built of redwood or anything other than pine. Under the doctrine of strict compliance, the requirement for pine was a condition on the contract, and it must be strictly met before the buyer is obliged to pay anything at all. The party requiring the condition to the contract can of course remove it. Once removed, the party is stopped from later requiring the condition. After the horse buyer declares, that I said I'd buy the mare only if she was in foal, but I've changed my mind and I'll buy the mare anyway. The condition that the mare is in foal is removed, and the buyer is obligated to buy her whether she's in foal or not. Removal of the condition before performance means the condition is excused. If the condition is removed after performance, it's deemed waived. The condition is waived when the fence buyer says, "Oh, you use redwood instead of pine? That's okay, I'll pay you anyway." After this waiver, the customer is obliged to pay for the fence, and is stopped from refusing to pay on grounds that the condition requiring pine was not met. Constructive conditions. A contract can be formed when the cleaner offers to wash the windows for $20 and the customer accepts. Although the contract is silent regarding when payment is due, it's customary that a window cleaner completes the job of washing all the windows on the house before tendering his bill and requesting payment. So, completion of the window cleaning is a condition to payment. It's not an express condition, as it was never expressly agreed, but it's a constructive condition. The difference between express and conductive conditions is in the degree of performance required. In an express condition, where the buyer, for example, states, "Okay, when you've cleaned all the windows, I'll pay you $20, strict compliance is required, and the $20 is not due until each and every window has been washed. When the contract is silent on the performance condition, substantial performance rather than strict performance is required by law. So if the buyer fails to require that all 20 windows be washed before payment is due, the court would likely support the cleaner's request for $18 after washing 18 of the 20 windows. The cleaner had substantially performed on the contract, and substantial performance means the constructive condition is met. Checks are of course a common form of payment, but they take time to clear the banks. Unless it's otherwise agreed, the buyer of goods under a contract with a payment deadline has a right to pay by check and write the check immediately before the deadline expires. The writing of the check meets the deadline, not the depositing of the check or its subsequent clearing. The buyer is not in breach if she writes the check before the deadline and tenders it to the seller. The seller, however, has a right to refuse the check. In this situation, the seller's refusal of the check as a form of payment does not place the buyer in breach when the deadline expires, as the seller must provide the buyer with a reasonable time to find cash or an acceptable form of payment. Refusal of the check effectively postpones the deadline. Some contracts are divisible and some are not. I agree to build you 200 apartments at $100,000 each. Is a contract divisible into 200 mini-contracts, one for each apartment? Under this agreement, the builder can demand $100,000 when each apartment completes. I'll build you 200 apartments for $20 million is an indivisible contract. Payment is contingent upon completion of all the 200 units. Novation. I introduce Fred, who will stand in for me. Is that okay? A party to a contract can be released from its obligation by being replaced with a substitute party. However, both the original parties and the substitute must agree. Otherwise, the duties to perform are not released. Once a party has been replaced through a novation, her duties are released and she cannot later be sued for breach. In a novation, both the original parties agree to the replacement, and the party replaced is relieved of his duties under the contract. If a party appoints a replacement without agreement from the other party, this is not a novation but a delegation. This is Tom, he'll be performing my duties under the contract. The original party to the contract has delegated his duties to Tom. If Tom fails to perform, it's not Tom who will be sued for breach, but the original contracting party that appointed him.